for your continued attention. Now the defense will have an opportunity to give their closing argument.
Good afternoon, everyone. So, as you already know, Miss Link is presumed innocent. You are required to presume that she is innocent. And that presumption is to stay with you throughout this trial until you go back there and deliberate. When you're back there deliberating, if you decide that the state has proven their case beyond all reasonable doubt, then that's another story. But she doesn't lose that presumption until you reach that decision, if you reach that decision. I don't know if you remember, because it's been a couple of weeks already, but during jury selection, there was a juror sitting in the back, in the corner. And we were talking about that example that I gave about the cat and the mouse and the hole in the box. Do you all remember that? Okay. There was this one juror, he was sitting in the back, and he said, I can't make a decision because I don't have enough information. Well, as I explained to him, the cat is presumed innocent. You're not convinced that the cat's guilty, right? No, I haven't been convinced. Okay, well then your decision is not guilty. He's presumed innocent. So your verdict, right? Your verdict is not guilty. If that changes, if you're convinced otherwise, then you change it. But if you're not, the verdict is not guilty. It's pretty simple. I would submit to you that right now, before I say another word, every single one of you should vote not guilty. I'll explain in a moment, but you should, because the state has not overcome the reasonable doubt in this case. Now remember, I will remind you, I don't have to prove that Miss Link was justified in pulling the trigger. They have to prove that she was not justified, and they haven't. Now, I want to talk a little bit about some of the things that the state said a moment ago. They said a lot. They said that Daisy was upset because Pedro wasn't home. There's no evidence of that. They just made that up. There is no evidence of that whatsoever. Whatsoever. Point to one witness, one piece of evidence that establishes that. You won't find it because it hasn't been introduced. It's their burden to prove it. They want to say something, they want to allege something, they have to prove it. They can't just get up here, say it, and say, oh, you got to believe us because we're the state. Believe everything we say, believe nothing that the defense say. We're the good guys. Doesn't work that way. They have to prove it. Daisy's mother flew in for a barbecue? That's what he said. You know that's not true. And they didn't even have that barbecue. And yes, they were going to have a barbecue the next day. You heard why. Number one, because she lives in Texas and she has other family that she doesn't get to see, so she's going to see them. And number two, they don't want to make it obvious that Daisy's leaving because they don't want Pedro to flip, which he did anyways. But they don't want him to flip, so they're doing it in a way that he won't find out. That was the testimony. Have they rebuffed that testimony? Have they proven that it's not true? No, they haven't. The most that they've done is, well, maybe it's true, maybe it wasn't. Have they disproven it? They have not. Can you point to a single piece of evidence, to testimony, to anything that rebuffs that? You cannot, because it doesn't exist. The state mentioned about phone calls between Pedro and Daisy. Pedro didn't have a phone because he tossed it after he almost beat Daisy to death a few days before. And then he had to get another phone. And you heard testimony about that. You heard testimony about that. When he went to his friend Kevin's house to do all that coke and to buy all that cocaine so he could have a party while he's driving a big rig across the state, snorting cocaine, he didn't have a phone. He didn't have a phone because he tossed the phone after he almost killed Daisy a few days before because he didn't want the police to track him. It wasn't evidence. She testified to it. I'm not making it up. I'm telling you what was in evidence. You can use your own recollection about what you heard, but we all know that that came out in evidence. I'm not making it up. The state has repeatedly said that was their home. No, it wasn't. They can't just say it and say, there, we proved it. They haven't proved it. This thing is really blurry. But for the future reference, this is Defense Exhibit A. It is 3 pages long. Pedro Jimenez had 2 driver's licenses. These driver licenses, both of them, can't see it here, but you can see it yourself when you go through the evidence. Both of them have his mother's address. You have seen lease agreements where he is not on the lease documents. You have heard testimony from multiple people, including his son, that said he didn't live there. But most importantly, this is Exhibit F, Defense Exhibit F. It's horrible. You can look at it when you're delivering. This is a court order. A court order. Now, the judge read the instructions, and I'm going to tell you exactly what the instruction that she read to you says. And I am talking about page 11 of the instructions, which you will all have with you in the back. Parental rights. The court has taken judicial notice that there are no court records in Miami-Dade terminating the parental rights of Pedro Jimenez. That is right. During my opening statement, I told you he lost his parental rights. I didn't say terminated, I said lost. When your parental rights are terminated, that means it's terminated. That means there's no coming back. They're gone. When you lose your parental rights, you can get it back. And this order provides a pathway for Pedro Jimenez to get his rights back. You know what that pathway is? First page, bottom. Substance abuse assessment, individual therapy, parenting therapy, domestic violence. Domestic violence. September 20th, 2019. Ever since September 20th, 2019, that man was limited to seeing his children by court order 1 time a month under the supervision of his mother, who you've heard doesn't even live in this state. And you've heard no evidence or any indication that she ever came back, because she didn't. And he gets to have FaceTime calls with the children at the sole discretion of the mother. The sole discretion of the mother. Do you think courts and judges limit a parent's ability to see their children flippantly and for no reason? They did it because Pedro Jimenez was a drug addict, a cocaine abuser, an alcohol abuser, and a wife-girlfriend abuser. And as you've heard throughout the course of this trial, he was doing nothing to get those rights back. He was doing the opposite. He was on his way to losing them permanently. Why? Because 5 days before he died, he beat Daisy Link halfway to death. Beat her halfway to death, smashed her skull in, did it in front of his 7-year-old son, did it in front of his 5-year-old daughter, did it in front of 4 other kids who were present. The state got up here and told you Pedro was not dangerous? Are you kidding me? Is that not the very definition of a dangerous man? He proved what he's capable of just 5 days before this happened. The state said a lot of things during their closing. I didn't agree with any of it except for 2 things. One thing that they acknowledged, Pedro was not a good guy. I agree. No, he wasn't a good guy. No, he was a cokehead, wife-beating lunatic. That's what he was. He terrorized and traumatized Daisy Link. He terrorized and traumatized his own children, and he terrorized and traumatized other children. This is a man that was capable of beating a woman halfway to death in front of children, in front of his own children. That's dangerous. Whether Daisy acted afraid of it or not doesn't change what he did. Whether Daisy made a flippant remark or made fun of him or insulted him doesn't change what he did. The state wants you to ignore and forget that he did that. Well, they can ask you to forget whatever, but you know what happened. This order Paragraph 3 of this order, Exhibit F, the minor children, Pedro Jimenez and Mia Jimenez, shall remain in the legal and physical custody of the mother, whose name is Daisy Link. Next paragraph, the non-custodial parent of Pedro Jimenez and Mia Jimenez is Pedro Jimenez. And then further down, Pedro Jimenez has not substantially complied with his case plan. A brief description of this plan is as follows: substance abuse treatment, assessment, individual therapy, parenting, domestic violence. He didn't do it then. He wasn't going to do it in 2022. And quite frankly, it's clear that he was never going to do it. He was less concerned with getting back his kids and having more time with his kids. He was more concerned with getting high and beating up Daisy Link. State will tell you that Pedro was broken, that Daisy did all these horrible things to you. They completely ignore what he did to her. And you can't ignore that because that goes to her state of mind. That goes to her state of mind right when she pulled the trigger. Yes, she went to pick him up. And I'll submit to you, that was a bad choice on her part. But you know what? Relationships are complicated. When 2 people love each other, even if it changes, it's complicated. When you add children to the mix, it's complicated. When you add property to the mix, it gets more complicated. When you add the fact that these kids, even though their dad's not a good guy, they love their dad. She knows that. So yes, she doesn't want to get him arrested. She doesn't want to get him deported. She doesn't want to do that. She just doesn't want to be with him anymore. And that's her right. And why would she want to be with him? He beats her up. He did so for almost the entire course of their relationship. And you need look no further than this order to know that. The state went on to say that Daisy Link picked up the casing, the spent casing in this case. There's no evidence of that, ladies and gentlemen. None whatsoever. They can say it till they're blue in the face. They have to prove it. It's their burden. And if they haven't proved it, which they haven't, then you can't accept it because it hasn't been proven. There's no evidence that she picked up any casing whatsoever. She was with police for almost an entire day from the point they got there at 3-something in the morning till she got to the station several hours later, till she started her 11-hour-long interrogation at what, 9? So she was done, what, the following evening? That's almost 24 hours. They had eyes on her the whole time. But they want you to believe that she found this casing and she got rid of it. Well, that doesn't jive with the evidence. There's no evidence of it. She told them where the gun was. She called 911. She tried to help this man as soon as she found him. And the only reason she didn't call 911 sooner is because Pedro stole her phone. The state said that the officers were kind to her. Are you kidding me? No, they weren't. They say that she threw a chair at Detective Morales. No, she didn't. There's no evidence of that. None whatsoever. There's 100 officers on there. All of them have body cams. Have you seen a single body cam of her throwing a chair at anybody? No, because she didn't. The state talked about Pedro Jr. They said one thing, and this is the other thing that I would agree with, that Pedro Jr. is a very smart boy. I agree, he is a very smart boy. Kids are honest. Yes, they are honest. And I would submit to you, Pedro Jr. was honest in his testimony. I specifically asked him, and he specifically said, I'm not telling you, nobody told me what to say. This is what I remember. Has he spoken to his grandmother in the last 3 years? Yes, because he lives with her. What's he supposed to do? What's he supposed to do? Because he speaks to his grandmother, therefore you shouldn't believe a word he says? You can judge that boy's credibility on your own. We have footage in this case which was deleted. It was lost while it was in police custody. The police only viewed one snippet, which is when Daisy Link went to Pedro while he was lying there. They didn't bother to look at anything else. They didn't bother to look at any other footage when he stole her purse or when he was running back and forth the 3, 4, 5 times that he was running back and forth, that Daisy's mother told him to leave, that Daisy told him to leave, or they threatened to call the police. There's none of that. It would have been on there, but they lost it. Nobody knows how. Everybody's saying, it wasn't me, I don't know, we did everything. It must have been the machine. It wasn't the machine. They gave the machine back to the owner. It worked fine. The only difference is a month's worth of footage is gone. I didn't delete it. The police did. The police lost it. The police destroyed it. What does that mean? They have it in their control and they lose it. That is incompetence of the highest order. This is a murder case. That is incompetence, ladies and gentlemen. You should consider that. We have a blood trail here, which begins in front of the house. The state will have you believe that at the time Pedro was shot, he was running away. He wasn't running away. He was running to the house. He was going to barricade himself inside that house where those kids were. He was going to keep her out, and he was going to do God knows what. I say God knows what because we already know what he did 5 days before. We already know that he snorted about a mountain of cocaine shortly before this happened. That was her home, which she has a right to defend. Pedro did not have an invitation or a right to be in that home. He made it clear that he was going to break into that home and lock her out and keep her away from her children, which he had no right to do. And importantly, she has every right to use deadly force to prevent him from doing that. And this is not just me talking. This is the law. This is the law, which I'm going to read to you in a moment. The law, I will remind you that each and every one of you swore an oath to follow. Was Daisy honest with the police from the get-go? No, she wasn't. Okay? No, she wasn't. Should she have been? Probably. But can someone really understand what's going through somebody's mind when they're in that position? I think we can all agree that what happened to Daisy Link in the 5 days leading up to this incident was extraordinarily traumatic. Unless you've been through it, it's hard to imagine what that's like. I would say it's almost impossible to imagine what that's like unless you've actually experienced it. It's very easy to second guess and judge somebody for their actions when you don't know what was in their mind at the time they made it, ladies and gentlemen. As I told you before, relationships are complicated. How many times, how common is it to see a couple who clearly are wrong for each other, who clearly shouldn't be together, but for whatever reason, they keep coming back to each other. They keep interacting. Maybe they separate, maybe they come back, maybe they go back. It happens. Well, that's because these things are complicated. There are children involved. There's a history involved. There's a familiarity involved. And yes, there's love involved. And that makes it very difficult. So it's very easy for us to say, you should have left. You shouldn't have called him back. You shouldn't have gone to pick him up. You should have called the police. You should have had him deported. Should have done all these things. I agree. She should have done all those things. They should have called the police. They should have done all these things differently. She didn't want to. Daisy told you why. Again, this is a court order. This court order says Pedro gets to see those kids once in person, see them in person, once a month with the supervision of his mother. Daisy had a fear, a reasonable fear, that if the court found out that she was allowing Pedro to see those kids in person, knowing that he's still being violent, knowing that he's still abusing drugs, a court could very easily and theoretically say, you know what, you're not supposed to have him around those kids. You know what he's doing. We're going to take those kids away from you. As a parent, is there anything scarier? Anything scarier than losing your kids? I don't think so. If you can think of something, I'd love to hear it. I can't think of anything. I'd rather be killed than lose my kids, personally. She feels the same way. That's why she did what she did. You can disagree with it. You can not like it. That's fine. That's your right. But that doesn't change the fact that at the time she pulled the trigger, she had every right to do so. This paper that you all have, jury instructions, this is the only law that applies in this case. There is no other law, no other instructions that apply to this case. You are to decide your verdict based on these instructions and these instructions alone. Okay? So let's go through the instructions. Page 3. This is really loud. Sorry. The best I can do, I'm sorry. Page 3. You all have it, so that helps. Justifiable homicide. Use of deadly force is justifiable if done while resisting an attempt to murder or commit a felony upon the defendant, in or upon any dwelling house which the defendant was at the time of the killing. Miss Link was at her home. She had every right to be there. Mr. Jimenez had no right to be there. I don't care if his kids were there. He had no right to be there. He had no right to see them. You saw the order. He did not live there. He did not have the keys. He was not on the lease. The address was not on his license. You've heard testimony from multiple people that he did not live there. You have not heard testimony from a single witness that said he lives there. They want you to believe he lives there because it's convenient for their case. They don't want you to believe that he didn't live there, which he didn't, because they know that if you know he didn't live there, they're done. Their case is over. And I'll explain that to you in a second. So the question is, has the state proven to you beyond a reasonable doubt that Pedro Jimenez lived in that house? No, they haven't. At best, maybe you can all say, yeah, I'm not sure. Maybe he did, maybe he didn't. What are they pointing to prove that he lived there? Because there are some shoes and some shirts that appear to be for males in the house? Does that prove he lived there? I'm sorry, it doesn't. And use your common sense, people, okay? I still have stuff at my old house, and I've been divorced for 10 years. It's still there. It's not my house. I don't live there. I don't have the key. I can't go there and come and go as I please. No, I have to knock on the door. I have to be allowed inside like everybody else. Was that my house before? Sure. It's not anymore. Do I still pay the mortgage? Yeah, I do, actually. But I still don't have a right to go in there because it's not my house anymore. That was not Pedro's house. And unless they prove that it was his house and that he lived there beyond a reasonable doubt, then no. And as far as you're concerned, that was not his house. He didn't live there. He did not have a right to be there. Same page, page 3, excusable homicide. The killing of a human being is excusable and therefore lawful. The killing is lawful, which means it's not illegal. It is lawful, not a crime. Under any one of these following circumstances, when the killing is committed by accident or misfortune, and doing any lawful act by any lawful means in the ordinary caution, okay? Number 2, when the killing occurs by accident and misfortune in the heat of passion, upon sudden and specific provocation. Can you see how that scenario could apply to this case? He's been asked to leave multiple times. You heard testimony from Daisy Link. Before she got the gun and fired, Mr. Jimenez grabbed her by her hair and threw her. And in grabbing her by her hair, he opened up the wounds that he created just days before, and he threw her to the ground. She's already told him to leave. She grabbed the gun. She told him, leave. And you heard what he said. I'm not leaving. I want to die. I'm ready to die. And then he ran to go break into the house. Then she fired. And then, and only then, when she fired, that's when he started running away. It took the shot. It took her firing the gun for him to abandon his intention to break into her house. And if you are stopping somebody from breaking into your house, that is justifiable use of deadly force. And it was going to happen imminently. We know that. We saw the blood trail. We heard the testimony. He was going to break into her house. She did everything she could to stop him. He refused. So she fired the gun. And it worked because when she fired the gun, he ran off to the alley. I want to talk about the instruction for second-degree murder. This is on page 4. You can see it there. Three elements that the state has to prove beyond a reasonable doubt in order for you to be able to convict Daisy Link. And this is what your case is going to come down to. Number two, the death was caused by the criminal act of the defendant. And number three, there was an unlawful killing. So I highlighted the relevant portions in 2 and 3, just to give you all a little guidance there. So in order for you to convict her of anything, whether it's murder or manslaughter, of anything, you have to find that her firing that gun was a criminal act and that her killing Pedro was unlawful. So, in other words, what your deliberations are going to come down to is whether or not this killing was justified or not. Was Daisy justified in using deadly force or not? That's it. That's the decision you have to make, and that's going to be how you reach your verdict, okay? It says it right there. So, let's fast forward here. This is the key instruction in this case, ladies and gentlemen, page 8. It's the longest instruction out of all of them. It's, oh boy, look at that. It's 3 pages. It's 3 pages long. So, sorry, but we need to go. Justifiable use of deadly force. Third paragraph, okay? Defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find her guilty, the state must prove beyond a reasonable doubt that she was not justified. This is what I said earlier. I don't have to prove that she was justified. It's the other way around. They have to prove she was not justified. So have they proven that she's not justified? Have they proven it beyond all reasonable doubt? Well, let's see. Let's have a look. Keep reading. The law on justifiable use of deadly force is as follows. Defendant is justified in using deadly force if she reasonably believed that such force was necessary to prevent the following: imminent death of great bodily harm to herself or another. So if she believes that imminently means it's about to happen, it's going to happen any moment now, that she's going to get hurt or another person's going to get hurt, you have the right to use deadly force in that instance, okay? And then there's another option, or B, the imminent commission of burglary or false imprisonment against herself or another. At the time that she shot, Pedro Jimenez was running to break into her house, to barricade her out of her house. Okay? He had no right to be there. When you enter somebody's house without permission, that's burglary. I'm going to read you the definition of burglary in a moment. So that's number one. That's one felony that he was about to commit, which, according to this instruction, if she knows that he's about to commit a burglary upon her house, she has the right to shoot him, to stop him. This is the law that you are required to follow. In addition to burglary, false imprisonment. There are 2 kids in that house. Those kids are in her custody, not in Pedro's custody, her custody. By barricading himself inside the house, Pedro would be illegally separating those kids by force from their mother, without permission, without authority, without any right to do so. She has a right to use deadly force if she has reason to believe that that's about to happen. And we all know that that was about to happen. He was about to burglarize her home. He was about to lock her out of her home and commit false imprisonment upon her kids. So moving on to the next part. This long paragraph here, right here on page 4, on page 8, This paragraph has to do with whether or not Daisy Link had a duty to retreat or not a duty to retreat. You can go through that and read it to yourself, but ladies and gentlemen, as you will see in a moment, she had no duty to retreat because she had every right to be there because that was her home. On the other hand, Pedro Jimenez had no right to be there because that was not his home. He had been told repeatedly to leave. He had been threatened that they would call the police. And he did leave, but he kept coming back. Multiple times, he kept coming back, kept terrorizing this woman. She did it while her mother was there, and then he did it again after his mother left. His mother left at 1:32 in the morning, and he still came back after that. He's terrorizing her at 3 o'clock, 3 something in the morning. I'm going to refer you to page 8 at the bottom right here. If the defendant was in a dwelling or residence in which she had a right to be, which she did, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent death or great bodily harm to herself or another, or the imminent commission of a burglary or a false imprisonment against herself or another. So again, this says, again, if she has reason to believe, well, first of all, it says if she's in a place where she has a right to be, there's no question she had every right to be there. That was her home. If she's in a place where she has a right to be, she can use deadly force to stop somebody from burglarizing her home and to stop somebody from keeping her outside of the home and keeping her away from her kids who are inside the home. She had a right to use deadly force in each of those and in both of those. This is the law that you are required to follow. After this defines the crimes of burglary and false imprisonment. These are the 2 crimes that I would submit to you. The evidence has clearly demonstrated Pedro Jimenez was intent on doing and was in the process of doing, and the only reason he stopped from doing it is because she fired that shot. That was the only way that she was going to stop him from doing that, and we know that from Pedro Jimenez himself. I'm ready to die. What does that mean? I'm going to do what I want. You want to stop me? You're going to have to kill me. You're going to have to kill me. Burglary. Entering a dwelling owned by or in the possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Please tell me, how has the state disproven that this was about to happen? Can you honestly say to me that the state has convinced you beyond all reasonable doubt that Pedro Jimenez was not in the process of rushing in to barricade himself inside that house and lock Daisy Link out? Have they disproven that beyond a reasonable doubt? If the answer is no, then your verdict is not guilty. If the answer is yes, then okay, then I would ask you to ask yourself, how have they proven it? What have they shown you? What have they introduced to prove that? I would submit to you they've introduced nothing to disprove that that man was going to do that. Certainly not beyond a reasonable doubt. That's burglary. False imprisonment. That's the next one. We're still on page 9. It's right here. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Forcibly would apply here. He was attempting to forcibly confine those kids within that house and keep the mother out of the house. The next paragraph defines secretly. You're free to read that as much as you want, but secretly doesn't apply here, so I'm not concerned with that. The next paragraph is very important. Very important. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In other words, if you're locking two kids inside a house against the will of those kids' legal guardian, and those kids are under the age of 13, which, as you already know, those kids were ages 7 and 5 at the time, then that's false imprisonment. We know that Pedro was not their legal guardian because that's what this order says. So unless the state is going to come up here and find a way to invalidate this court order, which if they have a way to do that, I'd love to hear it. They're not going to. This is a court order. This is a valid court order. And this court order was in place in full force on that night. Daisy Link asked him to leave. He did not respect her request to leave. He was going to commit false imprisonment. And that is what this instruction tells you. I'm going to keep reading. Please bear with me. But again, this is a long instruction, but it is the most important instruction in this case, because this is what your deliberations are going to come down to. In deciding whether the defendant was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. I'll say that again. The danger need not have been actual. So it's actually legal to use deadly force against somebody, even if there's no real danger. The key is whether the person using the force reasonably believed that the danger was there. Now, I would submit to you, there's no question that the danger was real. There's no question that the danger was imminent. But this instruction shows you that even in cases where there's no real danger, if you find that the person who used deadly force had reason to believe that there was a danger, that's enough. That's enough to say that the use of deadly force was justified and lawful. I'll keep reading. To justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Pedro told her, "You're going to have to kill me. I'm ready to die." What else was she supposed to believe? What else was she supposed to believe? She didn't put herself in that situation. He put her in that situation. The state will tell you, oh no, she brought him to the house, so it's her fault. No, she brought him to the house. She knew she was going to leave. First of all, she was supposed to pick him up and take him to his mother's house, but she explained to you she came back because he still had his keys. She wanted him to see the kids. She wanted to make it work so that she could get away from this man finally, move away from him, not have to deal with him beating her up. And she was implementing her plan. Whether it was a good plan or not, that's up to you to decide. But that was her plan. That's what you heard. It has not been refuted by the state in any way, shape, or form. She went to pick him up. She came over. She came over while her mother was there, and you heard from her mother and you heard from her. He was obviously high on cocaine because he used a bunch of cocaine at his friend's house. He bought a bunch of cocaine from his friend. He was drinking. You heard what was in his system when he died. He was extremely under the influence of a ridiculous amount of cocaine. He was drunk. He was out of control. She brought him back, and as soon as he started becoming violent, which he did on multiple occasions, as you heard from her mother and from her, as soon as that happened, he was told to leave. He was told, what, 5 different times to leave? And 5 different times he left. 5 different times he came back. You saw video of him running around. There's a video of him being told to leave a few hours before he was shot. How many times does this woman have to tell him to leave? You know, once is enough. Once is all it takes. It's my house. You need to leave. You need to leave. If you don't leave, you're committing a crime by not leaving. Okay? You're committing a crime. But he knew that she didn't want to call the police on him. He knew that for whatever reason, and she shouldn't have, but for whatever reason, unfortunately, she had a soft spot for this man, and she kept giving him opportunity after opportunity, even though, as we all know, she probably shouldn't have. But again, relationships are complicated, and you can judge her all you want, you can disagree with her all you want, but you don't know what it was like for her, and that's the decision she made. And it's understandable because, again, relationships are complicated. And that's the position that she was in. But she didn't create this position. She asked him to leave. He put her in that position by coming back repeatedly. I'm at the bottom of page 9. The defendant is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm to another, if, this is important, A, the person against whom the defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling, residence, or occupied vehicle. This is black and white. There's no room for interpretation here. You are presumed to be in reasonable fear and justified to use deadly force if somebody is in the process of unlawfully and forcefully entering your home. That is exactly what he was doing. And unless they can prove to you beyond all reasonable doubt that that's not what he was doing, then your verdict is not guilty. Anything other than that would be a disgrace. And I know you all don't want to make a disgrace here. I think you all want to get it right. There's only one right answer here, okay? I'm confident that you're going to get the right answer. I want to go to the next page. The next paragraph B. Defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring. This goes hand in hand with the previous one. Reason to believe it was occurring. He told her he was going to do it. He told her, you're going to have to kill me. And she saw him doing it. And the blood trail, which begins in front of that front door, corroborates what she told you. The state has given you nothing to dispute or disprove that. The next paragraph, this is page 10, right over here. The very next paragraph talks about situations where the presumption of reasonable fear does not apply. Okay? So if any of these examples, there's 4 examples. If any of them were to apply, then you could come to the conclusion that, okay, well, then this person didn't have a reasonable reason to believe that she was in danger of something bad happening to her. I'm going to start with the last one, with D, because this one's easy. The person against whom the defensive force is used is law enforcement. Well, Pedro Jimenez is not a law enforcement official, so we know D doesn't apply. So you can scratch out D. D is useless to you, okay? C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further a criminal activity. This doesn't apply either. Daisy was not using her home to conduct a criminal activity, and she was not committing a crime when she was just at home in her front yard, minding her own business. So C does not apply. You can disregard C. B, the person or persons sought to be removed is a child or grandchild. Pedro Jimenez is a grown man. He's a grown man who's 6'4" and weighs 250 or 60 pounds, and he could easily beat the crap out of Daisy whenever he wants, and he has on multiple occasions. So B doesn't apply. So all that's left is A. So let's read A. The person against whom the defensive force is used has the right to be or is a lawful resident of the residence, such as an owner, lessee, or title holder. Has the state proven to you, beyond a reasonable doubt, that Pedro is a lawful resident, owner, lessee, or title holder? No. They got up here and they told you over and over it was his home. He lived there. They were a family. They can say it till they're blue in the face. They have to prove it. Have they proven it? No. The only proof you've received on that topic is that it wasn't his home. You have lease agreements that he's not on. You have his license that he's not on. You have testimony showing that the locks were changed. You have testimony that he lived at his mother's house. Would he go over there to see the kids? Yes, but that doesn't mean that he lived there. All the evidence that you've heard proves that he did not live there. At best, you can say, well, maybe he did, maybe he didn't. But if that's your conclusion, then it has not been proven beyond a reasonable doubt. And again, the state has to prove their case beyond a reasonable doubt. They have not done so. I want to focus on this paragraph, which is right after A, B, C, and D. A person who unlawfully and by force enters or attempts to enter another's residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence. The fact that he was forcing his way into her house, according to this instruction, allows you to presume that he was doing so with the intent of committing a violent act and committing a crime, which is exactly what gives Daisy Link the right to use deadly force. And finally, and this is important, it's all important, but last paragraph, if you find that the defendant, who because of prior threats or difficulties with Pedro Jimenez had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Pedro Jimenez, you may consider that fact in determining whether her actions were those of a reasonable person. They had prior difficulties. You know all about them. Isn't it reasonable for Daisy Link to fear that this man could hurt her, to fear that this man could kill her when he just did this to her a few days before? Yes, you can judge her for communicating with him and spending time with him in the intervening days. But as she said, number one, she loved him. That clouded her judgment. Number two, when he wasn't on drugs, there was no problem. The problem was when he was on drugs. And we know, without question, he was on a lot of drugs when she shot him. And what did she say? When he's on drugs, when he's on cocaine, he's a monster. And that's what he is. That's what he is. Finally, ladies and gentlemen, at the beginning, top of page 11, in considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of the defendant and Pedro Jimenez. Pedro Jimenez is a man. Daisy Link is a woman. Daisy Link's not a petite woman. She's a larger woman. But Pedro Jimenez was a lot bigger than her, a lot stronger than her, a lot more dangerous than her, and he's proven that he could hurt her, and he did hurt her over and over and over again. You may not like her. You may disagree with her. You may think whatever you want to think. You may take exception to what she said on that video. You may do all that. But none of that changes the fact that at the time she fired that shot, that man was going to barricade himself inside that house. And according to the law, which you all swore you would follow, she was justified in using deadly force.
Mr. Alcala, can you go on? Supervision.
We stop the clock for this. Look here then.
Yeah.
This is the mesh before this shot. Look at on the lines, do something in the so walk the line, walk the line, thinking about how he's going to terrorize Daisy next. She's been doing all day. He's been told to do it 5 times. He's back again. You think he's back again for a good reason? You think he's back again to do something nice? You think he's back again to make up? No, he's back again to cause trouble. Does that sound like somebody who's in fear? No, that sounds like somebody who's coked out of his mind, somebody who likes to beat women up, somebody who likes to terrorize women, and somebody who's going to break into his ex-girlfriend's house because he can. Daisy Link is not guilty. Find her not guilty, please. Thank you.
Thank you. State,